Hi, good morning. My name is Kenneth Johnson. I have my guests here with me, Philip Arias, Micaiah Noah, and Mrs. Vaney Garcia. And everyone, I'm be going to screen share so that we could see the video. Can everybody see it?
Yes.
Okay. All right. Get this timer going. Okay, again, my name is Kenneth Johnson, and in 1985, I went to prison. And this prison photo right here was taken by inmates. Inmates took all the fingerprints in prison during that time. Both of these photos were taken by inmates. When I arrived at the prison, inmates also took 4 sets of fingerprints. They also wrote down my birth date, my name, gave me a number for the prison, and they wrote all these fingerprints on this official CDC 138 fingerprint card. Under the law, under the legislative law, it declares in Information Practice Act, which is Civil Code 1798.1, that declares that the right to privacy is personal and a fundamental right protected under Article 1 under Section 1, Article 1 of the Constitution of California and by the United States Constitution, that all individuals have a right to privacy in information pertaining to them. So we all have a right to privacy. And as you can see, my fingerprints and photos were taken by inmates. In 1990, that was in the 80s. I got out of prison in 88, and in 1995, I got 2 cases under the 3-strike law. This is one of them, the official filing. And the case carried 246, but under the enhancements, under the 3-strike law, which is Penal Code 1170-12, they enhanced my sentence. Also, I called another case in Compton with the same thing. This case carried 346 years, and they enhanced it again. During the trial, the district attorney sent to the prison the California Department of Corrections requesting records from the 1985 conviction when I was in prison. And they admitted it into evidence. And here's the record of everything I did during that time. And when I got to prison, then inmates put my fingerprint on the abstract of judgment, the order that from the judge in 1985 sending me to prison. An inmate put the print there. Inmates rolled these fingerprints again on the fingerprint card, and inmate took these photos during the course of time I was in prison. During trial, the DA calls the fingerprint expert who admits a different fingerprint card. He takes your print in the courtroom. He rolls these prints and he compares them to the prints that the DA office submitted. I mean, that the DA asked for from the prison. And the expert, he makes a comparison right there in the courtroom, and he puts the date 1996 on his fingerprint card that he checked these fingerprints against my fingerprint card. As you can see, the same dates 1996 on the fingerprint card that was done by inmates. So what happened here is the officer took fingerprints. The fingerprint expert took fingerprints, his fingerprints, and matched them to the fingerprints that the inmates took in prison. And there again, the date where he checked my fingerprints against his fingerprint card. The DA, he explains to the jury that these records came from the California Department of Correction, and he tells them that the thumbprint and the other fingerprints are certified by the Department of Corrections. And he shows them that, again, just a bigger picture of the same, that that these records are certified by the California Department of Correction. And he also speaks of the thumbprint, and he also speaks of the fingerprints that were put on the fingerprint cards. Afterwards, the jury makes a determination on a verdict form, and here the jury determined that the priors was true. Under the three-strike law, the judge calls that prior a strike, and he gives you he struck me out under the three-strike law, and he gave me a sentence of 25 years to life plus 2 5-year priors, 35 to life, and then 2 years extra for a total of 37 years to life in this case. And also in this case, he gave me an additional 25 plus 2 5-year enhancements for the total of 10. And then this 2 years, 37 to life for a total of 74 years to life. In prison, I appealed it because I didn't think it was right that my fingerprints were compared to fingerprints done by inmates were being compared to official fingerprints. So at that time, they told me there are no means to confirm your claim that these documents were prepared by inmates. So the Department of Correction denied my appeal, stating that there's no means to confirm your claim that these were prepared by inmates. Therefore, CDC will not be contacting the District Attorney, Department of Justice, or FBI. So I appealed it again. Excuse me. I appealed it again. This time, Officer Vargas at Chino, Correctional Officer Vargas, confirmed that during the mid-1980s, PWC inmates did in fact fingerprint incoming inmates. So they admit that inmates did the fingerprinting. And the warden stated that under Section 1029 that the peace officer, that the inmates were not excluded from performing the duty of a peace officer, did not preclude inmate workers from collecting fingerprints and taking photographs. However, under the government code 1029, this is the 1020, it disqualifies for a peace officer anyone who's been convicted of a felony. And CDC and the warden also said that inmates could do it in his letter stating here. However, so I wrote to the Secretary of State and asked for what was the laws back in the 80s. And he sent me these copies of the laws. Here it lays out who a peace officer is, who the employees are. It lays out, breaks down who the peace officer personnel is. He also, CDC filed for the Information Practice Act, the law I showed you in the beginning. And in it states that information in all records and files of the department which pertain to individuals, including inmates, employees, and other persons, will be collected, maintained, amended, and disclosed in conformance with all requirements of the Information Practice Act. So we're equal. And it also states the employee's responsibility. Nowhere in here does it mention about an inmate. And these documents is certified with the Secretary of the State seal. So under the Information Practice Act, this is how it looked back then. And now it also has that any person whom the department maintains a record or file containing personal information has a right to request amendment to correct outdated, inaccurate, or incomplete information. These are also records showing when the laws for inmates, allowing inmates to do it was done after 1995. But inmates still can't do your fingerprint. Here is the law showing that it was the R&R sergeant responsibility to put the fingerprint on the commitment form, that thumbprint at the top. So, and it's also R&R officer's responsibility to roll the fingerprints on the fingerprint card. Nowhere in here does it says an inmate can do this. Here's other laws putting it on the director of correction, the responsibility for these fingerprint cards and photographs. Here's showing that the evidence code showing that the document must be made within the scope and duty of a public employee. But these fingerprint cards were done by inmates. That thumbprint was put there by inmate. The sergeant signed it, taken by on the form, the CDC 138 form, as though the form was done, by an officer, but it was done by an inmate. No one in the courtroom when this fingerprint expert took my print, no one knew that he was comparing his prints to prints that were done by inmates. I received 37 to life right here for one of the cases under the enhancements due to the fingerprints, and another 37 to life for a total of 74 years to life. These are official records from the files of both of those cases. And based on these records, that were the sentence was enhanced. I served 25 years, 6 months. I just got out July 20th, 2020, and today I'm here, with you guys in class. Thankful to be a student at West LA College. But based on these certified documents from the state of California, Department of Corrections, I did a 3-strike sentence. But as of last Friday, my parole officer sent me this text, and right now I'm waiting on the official documents. But this text stated that Johnson, a BPH judge, discharged you effectively today. You are a free man. No need to report to parole. Enjoy. So basically, he told me to go and enjoy my life. I'm gonna stop the screen share here, and so my thesis statement is that the State Law Information Practice Act guarantees every individual the right to privacy and personal information collected and disclosed by a state agency, and the right to request amendment of records maintained by state agency containing incomplete information. My position is that my records are incomplete because the official duty was never done by the state. And that concludes my presentation. Thank you all for participating.
You're welcome. Have a good one.
All right.
Thank you.
You're welcome. I need to stop the recording.